Christine Kiesel is here to talk to us about advocating for your clients in child welfare matters. Christine Sabino Kiesel is an attorney and independent contractor and works as a child welfare specialist for JBS International, where she provides support to the Federal Children's Bureau, supporting legal and judicial integration into child welfare policy. Previously, Christine was the coordinator of the New York State Child Welfare Court Improvement Project, and I'm sure many, if not most of you, remember Christine in her former role. Christine came to that position after presiding over a best practice permanency part in Oneida County Family Court as a court attorney referee, and serving as a principal court attorney to the Honorable Frank S. Cook, Oneida County Family Court Judge, and the Honorable W. Dennis Duggan, Albany County Family Court Judge. Christine provides training on child welfare topics and supports child welfare system change work across the country. And I understand you're going to be doing a similar presentation in Nevada, is it? Nebraska. So you guys get to preview, yeah. Help me welcome Christine Kiesel.
Thank you. So I was talking to Seth Buckman before my presentation, and he said, you have a beautiful resume. And as I sit and I listen to it and all the various things, I'm like, it just makes me feel old. So I really hate that part. And for those of you who have asked me and sent me congratulations, I am not the executive director of the American Heart Association. Thank you for all your congratulations. Her name is spelled slightly differently than mine, but I appreciate people reaching out nonetheless. Okay, so what we're going to talk about today is really quality legal representation as attorneys for children. We're going to talk about some of the policy and practice considerations of quality legal representation. We're going to weave in some substantive issues around that, and we're going to follow up with some New York State case law about quality legal representation. In order for this to be successful and not be the thing that's keeping you from one of the rare days that there's some sun out there, I need some conversation and for it to be participatory, please. So as I walked in the room, I was really thrilled to see so many people that I know and have known for a long time and throughout that lengthy resume that was stated. So I know you'll have a lot to say. I know you have a lot of thoughts that'll go through your mind around this. So please help me out up here as we talk. Somebody said to me when I told them what I was doing today for all of you and said, you know you're going to be preaching to the choir, right? The people in the room are likely the ones providing the quality legal representation. Probably true, but listen with an open mind and open ears and say, am I doing that? Or do I see other people doing that? Do I have an opportunity to maybe bring somebody along that may not be providing quality legal representation? And I also tried to elevate the conversation so it's not the basic, let's go through Rule 72 and talk about how to represent your client. Okay, so there'll be some foundational points that we'll talk about, but we'll try to elevate those where we can, and again, I'll look to you to do that with me. All right, so I want to start by talking about what's happening nationally around quality legal representation. It's pretty exciting, actually, because around the country, and definitely at the federal level, there is a recognition that children and families will have better outcomes if they are represented by quality attorneys. So if you remember a long time ago, it used to be the thought that attorneys would just muck things up, right? People had this, not attorneys, but other people kind of had a sense that attorneys would really be a barrier in the case, especially when it comes to child welfare. Why can't we just do what's right for this child and not have those pesky attorneys get in the way? But now, in the area of child welfare, it's really seen as a best practice to improve outcomes for children and families. We still see states with limited or no legal representation for parents or children. All states are required to have a guardian ad litem appointed for children, but not necessarily an attorney to represent children. So that's already an elevation that New York has. There's still states where it's optional, not believed in. I've listened to a lot of hearings from different states where judges will say things to parents like, so I understand you're here today in this proceeding and you're willing to waive your attorney presence today, correct? I mean, that stuff is happening and it's real. So this movement toward quality legal representation is making an impact is really very, very big. Let's see. States are working on their child and family services plans, which is something that state agencies, child welfare agencies, have to submit to the federal government. And they're also working on their child and family services reviews, program improvement plans. In those plans, they're collaborating with lawyers, they're collaborating with judges, and they're putting in part of their plan that they're going to be held accountable to, that they're going to elevate the quality of legal representation in their states. And the court improvement program, which, as Linda said, I used to run here in New York, again, a federally funded program. In their next iteration of their program instruction for their next 5 years as to what they're going to do, they're going to be required to have a project to improve the quality of legal representation across the state. Yeah, for a state like New York, that's an interesting thing, right? Because we already know all children get attorneys, parents get attorneys for the very most part, and we have specialized entities that provide training and resources and all those kinds of things. So I think what I want to put to you to start off is, in your opinion, and based on your collective experience, what do you think could improve the quality of legal representation in our state? How does more money make better lawyers?
Wait, sir. Can you speak in the mic?
I'm not saying it doesn't. I'm just asking you how.
Well, I think it's obvious that if you pay, that lawyers are, good experienced lawyers are charging $300 an hour in this area, and if the AFC hourly rate is at 75, if you're trying to draw in people who you know, are at the top of the legal game, you have to pay better hourly rate. And I think that's true everywhere.
So we need more people doing this work, is what I heard in that too.
Well, I mean, if you're talking about quality of representation, traditionally, the higher quality lawyers charge higher hourly rates. So if you want to draw in people of higher quality, you're going to have to get the rates up. And a lot of the people doing this work are very high quality people. They deserve a higher hourly rate. It's not as if, you know, these are very good lawyers. They shouldn't be relegated to an hourly rate of $75 an hour, right? It's too low.
I would agree with that. And what does that do to caseloads when you have a lower hourly rate?
That's what I was going to mention. I was going to say something very similar, but it's because if you're getting $75 an hour, you have to carry a higher caseload to keep up with the standard of living and cost of living and everything else, which then deteriorates the quality of your representation if your caseload is too high.
Right, right. What else? There was a lot of buzz. What else? Who else? I think we're waiting for microphones, since she's coming to you.
Yeah. Oh, Jen, thank you so much. I was just going to say, yeah, more money would be great. But really, in this area in particular, it's just got to be people who care about what they're doing. That's how I feel about it. But I don't have a Mercedes like Ralph either.
If you care about what you're doing, you're more likely to represent your client in a quality way. That's what you're saying. There was another comment in the corner. You're going to get your steps in, Jen.
Yes.
Well, I'm speaking for the rural counties where the panel lists are not all that large. Unfortunately, judges' hands are tied in terms of weeding out lawyers who, in their opinion, aren't prepared, not on time, haven't met with their children, don't advocate and prepare for hearings. But with the list so limited in some of the rural counties, the judges don't have much of a choice. So I guess encouraging more people that really want to do it and willing to put in the time would be one way to get better representation. But with the limited panels, judges really can't kick them any off or just ignore them on the list, because you get so many conflicts, you've got to reach down that list where you might not want to otherwise.
Do you have any suggestions for how we get more quality people to want to be on the list besides the money?
Or vacation. Advertise more, I guess.
One of the problems that we have in Onondaga County, and it may be other counties, is the the poor way family court is run. And I know a lot of people that won't practice there because you may have a case on at 9 o'clock and you don't get in to argue it or to comment on it until 11 o'clock. And you've got now people backed up at your office who you made appointments for, and that probably is I think the biggest problem. Criminal court, you don't have that. I don't know why they don't, and family court does, but it's a big problem, and I think sooner or later it's got to be overhauled.
That's a great point. So many of these issues are intertwined, right? Nothing's mutually exclusive anymore. You can't just say, oh, it's just the lawyers. And that's what we talk about when we talk about the child welfare system. The child welfare system no longer means the child welfare agency. It means the lawyers, the judges, the caseworkers, the service providers, the mediators, the support personnel. Everybody has a contribution to the effective operation of the child welfare system largely. So thank you for raising that point, because everybody needs to, when you're looking at how to improve quality legal representation, it may cross over, and it will likely cross over, not just from the attorneys, but the courts and how we're training and other things as well. Thank you for that.
There's no question about it. Ralph brought up a very good point, and it goes to the gentleman who was talking about pay. Because you're standing around in a hallway for 3 hours doing nothing, and what, we're going to ask the taxpayers to pay $300 an hour? I don't think so. I mean, that's part of the reason the rate is where it is, I think. But family court is frustrating. I will echo Ralph on that.
It's challenging, isn't it?
Challenging, that might be a good word.
All right. So thank you. That was great. Really good discussion. In your handouts is it came from the federal government. It says indicators of quality legal representation. And I want to look at a few of the items on here, recognizing that that list is for all attorneys, not just for attorneys for children. But there's some things on there that I think we can talk about and have real nice discussion around. But let's start with something that's easy on that list. It says attorneys should be present in court. No kidding, right? Sounds simple. Attorneys should be present in court. There was a hearing quality study done in Oneida County of permanency hearings in 2017. A case file review that was done incident to that project showed that 39% of adjournments of permanency hearings were due to late or missing parties, including attorneys. Yeah, it's being pointed out that some of that is on family court, because sometimes an attorney may not even get notice that something was on. With a permanency hearing, though, you should have notice, because that gets scheduled at the neglect. There should be notice there. So these were permanency hearings. Yeah, but agreed, everybody's got a piece to share. But what I will say is, how many people do respondent parent representation in addition to attorney for children? Okay. I'm going to say the percentage that I just talked about there are likely more respondent parents attorneys. And I say that because the study also had court observation of permanency hearings. And in the court observations, 100% of attorneys for children were present for the permanency hearings. 100%.
Respondents don't show up until sometimes half an hour late, which throws everybody off for the rest of the day.
Yeah. Respondents sometimes don't show up until like a half an hour late, and it's just a domino effect. It has everybody late for the rest of the day.
Sorry.
All right. I did a little bit of a survey with the 4 Oneida County judges in anticipation of this conversation, because it was the judges that requested this conversation. So I really wanted to make sure that I spoke to things that were important to them. So along the way through this presentation, we'll talk about the note from the judges. All right, so this is a note from the judges about attorneys being present in court. The judge said, while attorneys are usually present, they're not always timely. The judge asked that you be mindful of the time that each of your cases is going to take throughout the day, keeping in mind that each court may end up a bit behind. And always provide information to the court that you have another appearance, what time you have that appearance, And generally, the court will accommodate if they know that you're time crunched. So that's your note for the judges on that. All right. Attorneys should actively participate in hearings. It's another item from the quality legal representation indicators, right? So in order to actively participate, you must actively participate outside of hearings. What does that mean? Visit with your client. Yep. Loud. Be prepared. What does it mean to be prepared? Review the file. Talk to collateral sources. Yes. Engage in settlement negotiations before you get to court. Yep, yep, I'm hearing yep, yep. Okay. Generally find out information to support your position. Is the same way that you were advocating for an adult, right? So the child's position may not need exploration, but the underlying basis for that position, certain occurrences, certain conditions, et cetera, that may need exploration. So it's not enough, right, to just talk to your client, get their position, and say, well, that's what I'm going for. Because we'll talk about later on that you may be in the position where you need to put some evidence on to support that position. So it's outside of court as well as inside of court. You're not there as the resolver of the case, right? And I think people forget that who don't do AFC work. How often are you asked, well, so what did the child say about it? All the time, right? What did the child say about it? And sometimes we forget because you know that if you just know what the child said, it could maybe push this toward resolution. But the child's entitled to the same level of confidentiality of their conversations to you than your adult client. And unless you got permission to say what the child said about it, you can't tell it. So you're not there to resolve the case. And I think that still happens a lot, or that you're asked a lot about that. You just heard from Barbara, your responsibilities are to issue subpoenas, right, engage in discovery, call witnesses, and you clearly can't rely on somebody else to bring out the information you want to bring forth. Another note from the judges. I know you love these, right? Judge said, you are an advocate for the child. You must form that position well in advance of any hearings. Please don't use the hearing as a vehicle for information gathering so that you can decide your position after hearing the evidence. The judge says that happens frequently. Don't have a position before you hear the evidence and just kind of waiting and seeing what comes out and then taking a position after the fact. Not quality legal representation, right? But the people in here know that. Yes.
Yep. That's all well and good, but if the attorney for one of the adult parents doesn't give you permission to talk to their client, how do you get that information?
Right. Well, you can use one of the discovery items that Barbara was talking about to get some information.
Okay. On that same point, sometimes that's not as easy as it might seem if you've got like a baby client and you've met with them and you've observed their condition and all of that. But sometimes you've got, parties that are slinging allegations at each other and nothing's been proven. So you really can't, sometimes it's hard to take a position when you haven't heard any proof on any of this.
It is sometimes hard, which is why in those cases, you really have to roll up your sleeves and do as much research and information gathering as you can before that in order to find out how you're going to advocate for your client. And thank you for saying all of that you said that you do for infants, because we all know, right, that infants require that we see them and we communicate with them somehow. And it's usually that we go see them where they're residing and see what they're residing in and observe their behavior and their interactions with their caregivers, all of that. I think we've talked about that for years now. So thank you, Martha, for underscoring that for me. Of course.
Problems, though, of course, with that is how do you do some of that without making yourself a witness in the case, especially if you're going, as I often do, if it's a baby to the person's, the current custodial parent's house, and then, what if the other side is going to bring up some issues about the condition of the home?
So I just had this exact conversation about seeing a child in their home and whether that makes you a witness, and it was with a group of judges in the 5th Judicial District just last week. And I said, well, I would argue that that's the only way that I can communicate with my client. So I think it's privileged communication, it's attorney-client privilege, it's also work product. It's the only way I'm gathering information is being there. I said, so, judges, how would you rule with that argument? And they all agreed that they would not permit me to testify as a witness, but they said if I wanted to talk about the conditions of the home at all, I had to prove my case independently of my observations, which I was like, well, yeah, of course, but, right? So they would not allow me to be a witness to that.
As someone who worked for DSS for several years, my experience has been largely that the AFCs ride on my coattails for the whole trial, and so few of them do anything, and it just really made me want to throttle them. They were just in it for the money. It was an easy $75 an hour and whatever they made driving there. And they weren't prepared. They didn't know what was going on. They saw the kid once. It was 8 months in the past, and they knew I would do all the work for them.
You just made people very grumbly. What I would say is this, next judge's note. Come to trial prepared to prove a case. That is, having subpoenaed witnesses and documents, having prepared witnesses. They seem to rely on someone else, DSS or a respondent's lawyer, to put in a case which the AFC will supplement, but are not prepared to make their own case if the other counsel doesn't do the job which the AFC expected. That's the Matter of Payne case that Barbara talked about, right? Yeah.
Counterpoint to that is a lot of petitioners come in and they say, well,
Second, please, I'm sorry. I'm still in the coffee trough.
the counterpoint to that is a lot of petitioners' attorneys will come into court and say, I want a modification of an order of custody because it's what my kid wants. That's not the burden of proof. You have to be prepared to come in with something to demonstrate that there is a change in circumstances. You can't rely on what the kid is going to say because that's not going to come into court. So there's another side of it as well. And so sometimes it's up to the petitioner to satisfy that burden.
It is, but if your client wants that same thing as the petitioner and they're not going to do it, or you don't know that they're going to do it, you should be prepared to do it as well. Right?
Legitimate reasons other than it's what preference alone isn't going to become determinative of the case. So just because the child may have a position that they want to live with one parent or another, there may not be any legitimate basis for that to prove to the court why that it should be modified other than preference alone.
But that's a judicial decision, right? If you're representing that kid, does it matter that you have a client that is directing you as to what to do?
Sure, and you can still advocate for that and try to put on a
Right.
case, but again, that isn't always going to carry the day.
Correct. Correct. Yep. Yep. And before I go to any more judges' notes later on, I do want to say that the judges, all of them said that generally they find the quality of legal representation is strong, but they had some concerns. So lest anybody leave here feeling like the judges think they're doing a bad job, I didn't want to give that impression. All right, let's shift and talk about some specific areas of advocacy in child welfare cases. Let's talk about reasonable efforts. That's a really important tool in your toolbox that is rarely used. It can really change the trajectory of your case and also improve a system for your future cases. It shouldn't just be a checkbox, which it often is. It should be a meaningful discussion of the needs of a family and how the agency is going to meet those needs, what they're actually going to do about that. So often we see that cookie cutter menu of services. That, I will tell you, is not reasonable efforts. If those services are not specifically designed to help the family ameliorate some of the issues that brought them to the attention of the court. Is anybody familiar, I know my DSS attorney will be, and others will be, anybody familiar with what they call the RAP? Or the risk assessment profile? I'm seeing more nods when I didn't use the acronym. All right, for those of you who aren't, that is the child welfare tool that tells them what risks are present in this family, and that is the basis for the services that they are recommending for the family. It's not like a secret document. We talk to judges all the time. Judges are like, can we ask for that? Yes, you can ask for that. You too, as AFCs, can ask for that, or if you're respondent parent counsel. Upon what basis are you making these recommendations for services? Are they really tailored to the family's needs? Are they actually providing efforts that are going to move your client to the position that he or she wants to be in? And the RAP is a good place to start with that. So there's a few reasonable efforts determinations. Yeah.
Now, yeah. Is that available online, or is it in the code of rules and regulations? Where is it? Is it is it across the state uniform?
Yeah, it's an evidence-based tool that's used across the state. It is uniform. It is the tool that the Office of Children and Family Services has adopted. I think the tool might be available online if you Google it. I can't say that for certain. I would be surprised if it wasn't. But it's a family assessment of risk.
Thank you.
Mm-hmm. It's a RAP, R-A-P, Risk Assessment Profile. Yep. Yep.
To the RAP, how many times or across how many court sessions is a RAP modified and or updated, and is there a rule that says it needs to be?
Yeah, I think that's based in policy, not regulation. I'm going to look to my former DSS attorney to see if she knows that. Is the answer, you don't know, it's not, the answer is no. Not sure, that's a good question. I do know that the RAP gets followed up at some point with a family assessment and service plan, where again, people come together to talk about the needs and services of the family, and what the permanency goals should be and all of that. So that's another opportunity to do that. There's administrative reviews that happen in those FASPs every 6 months. So there are opportunities to continually think about and talk about those. And you can go. You can go. I know. Well, you can try. You can try to, not schedule a court case at that point, but, yeah. For busy attorneys with high caseloads, I get it, but it is available to you. Yep, so when are the reasonable efforts determinations made? When's the first one? Yikes. Removal, yes. There has to be reasonable efforts to prevent removal made. We'll talk about kind of what happens for our clients at removal also. And when's the next one? Permanency hearings. Permanency hearings, reasonable efforts to effectuate the goal, whether those reasonable efforts were made, right? If they're not made, how is this case progressing? If you have a client that wants to go home, you better advocate for reasonable efforts to be made, or a finding that reasonable efforts have not been made if they really haven't been made. One of the findings across the state of that permanency hearing, quality hearing study that was done was that the observers said in a qualitative kind of way, they said, we are seeing over and over and over again permanency hearings where the judges are clearly frustrated that the agency hasn't done what was required of them or done enough to get this child toward permanency. And so you think that no reasonable efforts finding is coming. And my people that worked in court improvement, they were like, and then all of a sudden, guess what? Reasonable efforts were made. Boxes checked. Why? To move the case along, there's one reason. Keep the peace. I think it's also because of the funding, right? The 4E funding. Judges were trained when the whole permanency hearings came out and tied to 4E and those no reasonable efforts finding, they were trained to be scared, to be concerned that if they make a no reasonable efforts finding, that the agency is not getting money for that child, which then is, less money for services for your children at large. But at the permanency hearing, when there's no reasonable efforts finding, the agency has an opportunity to cure. They can come in the next day and say, that one referral that you thought was really important, that if I didn't do, was causing us to have no reasonable efforts, here's an affidavit, the referral was made. And then guess what? In that one day, they lost 1 day of money. It can be reinstated. So it's really an important tool to move things forward on your case and on future cases, to hold the court and the agency and everybody accountable to a certain standard. I think your microphone's coming.
Oh, this way.
If you've really got concerns that they're not making reasonable efforts, you can also commence it and adjourn out a couple weeks and have them get their ducks in a row.
Yep. It's a strategy too.
I guess, I don't know if you're going to ask if anybody in here, if there have been any no reasonable efforts finding in their
Let's
cases.
ask it.
Oh, yes.
Oh, yes.
How many people?
But it was vindictive on the part of the judge, and also what I saw was.
Just a second, please, ma'am, this is great.
I'm so sorry.
She said it was vindictive on the part of the judges.
But what I see a lot is when respondents' attorneys have nothing to argue, they will say DSS didn't do this or this or this. They didn't drive. They didn't show up. They didn't pick the person up for the appointment. And the caseworker's not there. And then when I go to the caseworker and say, what happened? She's like, I was there. I knocked on the door for, 20 minutes. And the person didn't come to the door or wasn't even home. And so the attorneys will misrepresent something because it's the only thing they can grab onto is that it's DSS's fault. So I have had judges make that finding, but it was a particular judge.
Okay, so thank you. Who has had a no reasonable efforts finding made? It's on your question. So who has had a no reasonable efforts finding made that changed the trajectory of the case?
I believe I have.
There's a few.
There were 2 of them, but I still ask now, but sometimes I hesitate because DSS gets upset, and then it seems like I'm at war with them, which is why I say the findings are there to keep the peace. But one time I asked the county legislatures, they tried for 3 months to figure out how much money DSS lost. They couldn't figure it out. But I think it does make changes for that case and in the future because they know it is an issue.
Yep. Thank you. All right. I guess I'm going to tell you, don't be afraid to challenge the status quo.
Christine, as you know, I sat in the permanency part. And I did just what you said. When no reasonable efforts were made, it wasn't the lawyers, it was the social services, but they didn't do anything. And they're ready to adjourn the case for another 6 months. And when I said no, they all looked at me like I was the devil. Like, how dare you do that? Well, what happened is just what you said. Several days, we put the case over for a week, and suddenly efforts were made. Services were put in place because of just what you said, money. And that happened quite a bit. Of course, in the beginning, too, we had a lot of lawyers who didn't see their clients. And Judge Kay got on that issue and said, I'd asked the lawyers everything, when's the last time you saw your client? Well, I'm going to see them soon. Well, no, you're going to see them in the next 20 days or you're going to be taken off the case. And these lawyers were all my friends, but they weren't seeing the clients. And it was just a matter of shuffling these kids and young adults onto another 6-month schedule. But what you stated, the money issue, that was a great catalyst.
And Bill, let me ask you a question because I'm familiar with the referee model of the permanency parts. Was it you that identified that there may have been no reasonable efforts, or was it advocated for to have that finding?
Well, sadly enough, it was me. It wasn't the lawyers. The lawyers who would show up sometimes were just not tuned into that procedure. They got more tuned in when they realized if they didn't see their clients, they were going to be removed from the case and couldn't bill it out. But I think that situation has changed radically. And social services was responsive. It's just in some cases, nothing had been done.
Thank you. Okay, let's move on. I said to Linda before I started, I'm like, yeah, this is the first time I'm doing this presentation, although I have to do it in Nebraska, and I'm not sure I've got enough material for an hour. Yeah, we could hang here for a couple hours, just saying.
I just want to say, I think there's another issue, probably one of many other issues, but it's the quality of the reasonable efforts. I mean, you know, you make a finding day one, no reasonable efforts, and day two they come in with an affidavit about a referral. I hardly think that really changes the quality of the efforts that were allegedly reasonable. And I mean, these things are supposed to be tailored to the needs and the individual characteristics of the clients. They're not just supposed to be, okay, you send them to parenting classes and whatever, therapy you can hardly send them to anymore, but there aren't any resources. But I mean, I think that's a very fertile ground for exploration by lawyers. I don't know whether you would agree with this. And also, I think more lawyers probably don't advocate too much against these reasonable efforts, because I think that, in my opinion, the judges just apply them and find them in such a routine way. You know, it's just like a little postscript at the end of the
It's a
hearing.
checkbox.
Yeah.
Yep. No, I agree with you 100%. That definition of reasonable and reasonable efforts, it's not just efforts, but it's reasonable. Reasonable to the family's unique situation, the child's unique situation, and grounded in something to attach to about what they're doing. Absolutely. Thank you. All right, let's move on. Another bullet from our indicators of quality legal representation is early appointments of AFC. Who thinks that the way it's done in New York is early enough? AFCs are appointed when the petition's filed. Who thinks it's not early enough?
Are you operating from the basis they're appointed when the petition is filed?
Yes.
In the 5th District, that's changed under Judge Tormey. You don't get appointed until often the first appearance sometimes. You know, they want to do the first appearance. So you're talking about apples and oranges, respectfully, because the 5th District has their own way of doing things. They changed it years ago.
Oneida's still calling from appointment in the back office at the filing. Not always. They are on emergencies, right? Removals? Okay. So let's take the universe of removal cases and being appointed at the filing. Early enough? Who says yes? Who says no? Why not?
Because when you come into court, the DSS attorneys are armed and ready to go. They've talked to their witnesses, they have everything lined up, and you are there, you haven't talked to your client, you have no witnesses, you don't know what's going on, and you're sideswiped. So it's too late.
Is it too late? What do you do when you go in on that removal, and what do you do? The judge wants to make a decision based on imminent risk. You have a petition in front of you with affidavits. What do you do?
I argued against imminent risk because just last Friday, there was a 1022, and mom went out and decided to use Molly, but she had the child with a babysitter. She didn't pick the child up until 2 days later. She had a plan, a safety plan, but DSS came in and said, mom's using heroin, mom's using Molly, she's done. I didn't see it that way. I didn't see that there was reasonable efforts to see that she wasn't under the influence when she was using. She did have a safety plan. Judge didn't want to hear it. Done.
Are you representing mom or kid?
Child.
What if when you talk to your kid, they told you all sorts of other crazy stuff that you were like, not
Child's 5 months old.
necessarily. Well, okay, you got an infant. You have an infant. But what if that's the case? So you go just on the petition, you're in that removal hearing, you look at that, and you're going to take a position on behalf of your client. Should you do it?
You have to.
Can you ask for an adjournment? A brief adjournment, so you can do some, if you don't have a 5-month-old, talk to your client, gather some information? How can you take a position on that? You're at a very, you raised it, you're at a huge disadvantage, right? You have a child welfare agency that knows the family likely, sometimes they don't, but more often than not, they do. They know the circumstances, they know the situation, they know the people. And you're coming in like, I don't know if any of this is what it seems. It might seem like really scary stuff. Your inclination might be to say, listen, I'm just gonna consent and we'll work it out later. I'll go talk to my kid, I'll figure it out. That is a scary, scary tactic.
Christine, I agree with you, but how would you be appointed earlier? What would be the mechanism for you to be appointed?
So, across the country, there are pilots happening, what they call early representation. And what they're talking about, and the biggest model that everybody knows about is in Detroit, Michigan, and now it's going to be Michigan statewide. And what the social service agency does is when they have a case that they don't feel, they have the scaling system, 1 to 3, 1 being like really serious, we got to get the kid out, nothing else is going to help that. But if it's like a 2, that this child could be removed like at any time, it's kind of really shaky, they referred it for, there was an organization that got private funding, but now they can use public funding. Title 4E allows for parent representation and child representation. So there's funding there to do it outside of the context that we have. And they were having all of the issues that could possibly cause the child come into care addressed. So they would be there for, it was, Social Security issues, or there was an eviction issues, or they couldn't get the child into mental health counseling. They were there to try to help those issues. And let me tell you, they had 100% success rate. None of those children came into care. So there is a model out there. It's really very exploratory. And for us, it requires a whole lot of different thinking. The first time I heard about it, I was like, really? So I get it that it sounds very new and strange. But I'm excited to watch and see what happens. There's also another pilot similar to that in Marion County in California, and see whether we can keep kids out of care. Because, right, that's the push right now. Are people familiar with the Family First Prevention Services Act? Yes. It allows child welfare agencies to use $40, which has been the primary funding source for foster care, and actually served for the longest time to incentivize foster care, because that's how DSS has got the majority of their money. Now they can use Title 4E dollars for prevention services in the home. And there's a lot of qualifiers with that would probably take a whole nother session to talk about. So don't go saying, you can use $40 to do this. There's a lot of parameters around that. But that's the vehicle for making that happen. Yes.
Thank you. I think I had the same reaction that you had. I mean, does that mean like a lawyer for every family? I mean, what are we talking about here?
It was actually parent attorney and child attorney.
I mean, the whole system is sort of reactive, right?
Mm-hmm.
When something happens, petitions get filed and people go to court, and I don't know how you can do it up front. I mean, it's nice. I just don't see how it could be fiscally or administratively handled. I really don't.
Fiscally, I think there's a lot of benefit to it. You're not coming to court, you're not using judicial resources, you're keeping kids out of foster care. There's a huge fiscal benefit to that.
But what are we doing, the lawyers? What is it you're thinking about we're going to be doing?
You're advocating for family preservation, and the things that are causing risk to that preservation, you're helping the family address. That's
Wow.
the model. I know, right? Wow.
I'll give you the wow.
It's different. It's really something different to think about.
Why do we need lawyers to do that? Why can't it be done by some type of social agency? You're not talking about going into any court.
Sometimes you are. Sometimes it's eviction proceedings or Social Security denials or things like that. They're legal issues that they're referring. They need lawyers. They have social workers too that help. I'm just saying it's a different way of doing that. Nobody's put that forth in the legislature for New York State. I'm just trying to think about what you said is the quintessential piece for me. Did you read, I put in your material the 2 articles by Judge Edwards, but one is Representation of Parents and Children The importance of early appointment. Did anybody get a chance to read that? Read it. That was the piece for me that I read that made me go, yeah, this isn't right. Parents' attorneys and children's attorneys come in with so much less information on these families. You're already at a disadvantage when you come to the courthouse door. Already at a disadvantage, and you're expected to make like snap decisions, right? You're supposed to take a position and advocate for that really quickly without enough time to really do what you need to do in order to effectuate quality legal representation. So read it. He advocates actually for a model that says at petition filing. I'm interested to hear what you said about that. I did not know that. It's interesting, a very interesting issue. But I would encourage you to definitely read that. All right, let me see. I think I'm in trouble. Right. Yep. So there are a couple other areas that I wanted to talk about in this kind of conversation, policy practice. So I'm just going to ask the group what you would prefer. Would you prefer us still having these types of conversations, or would you prefer we go to the case law and talk about some of those cases that I had in your handouts? How many want this conversation to continue? How many want the case law? Okay. Sorry, case law, policy wins. The case law is in there. You can read it. You can Google them. It's, you know, the representation stuff, not just in child welfare, but really practice issues. That kind of ties some of this conversation in, so I hope you will go back and look at them. But Barbara actually did some of my work for me because I have the Matter of Payne in your handouts. So she already did that piece. So you got some case law, just not from me. All right, moving on. Another element from the indicators sheet. Attorneys should have specialized child welfare training. So everybody here, me included, underwent mandatory child welfare training, right, in order to become an attorney for the child. You were probably trained by the wonderful Margaret Burt on the basics of child welfare law. And in that 2-day session, you were also trained on J.D. Pinn's custody, visitation, and family offenses. Honestly, to do a thorough job on child welfare, the laws, the practices, the best practices, child development, other things, it really requires at least a couple of days. I used to be asked to train at the Judicial Institute for the judges on just child welfare, and they used to give me 1 full day, and that wasn't even close to enough, especially for judges, and sometimes attorneys come to this work without any experience with it, and you have to start off with the yellow book and what's in it, what the sections are, and walking through it. A real detailed understanding and foundational understanding of child welfare takes a long time, right? It takes not just reading the statutes, but understanding the case law that may be in conflict with the statutes and the practices and the best practices and the policies that are within your child welfare agency that are influencing what's happening in the courtroom and how the courtroom operates and how the different courtrooms operate, right? And the pieces of evidence and all of those kinds of things. So there's a lot. It's very nuanced. And you have to understand all of those nuances. The National Council for Juvenile and Family Court Judges, they have a Child Abuse and Neglect Institute. Unfortunately, at this point, it's only for judges. It's a great, great training, and it's been researched and studied and found to be very effective. It's a week long. It's a week long, and it's in Reno. So if anybody wants to advocate for them expanding it to lawyers, I understand it's not just a great training, but it's a good time. There is a national training by the National Association of Counsel for Children. Are you guys familiar with that organization at all? You should look them up. They do really good work around supporting advocates for children. And they have a program called the Red Book Training. And actually, if you take the Red Book Training, which I did, it was really very good and comprehensive. It makes you understand your state statutes in the context of all the federal child welfare law that is foundational to what the states implement. It makes you go, oh, okay, that's why we do this that way. And makes you understand the progression of child welfare over the years and just gives you a more comprehensive look. From that training, you can also take a test to be certified as a child welfare specialist. And so you can have that specialist certification attached to your degree, in your law degree. All right. Note from the judges around the training. Some attorneys, I know you love the notes from the judges, some attorneys are not strong enough in their knowledge of child welfare laws to effectively represent their clients. There should be regular ongoing training for not just the law, but an understanding of things like trauma-informed care and child development. So I would just encourage you. I think the initial training is good. I know the 4th Department puts on a lot of great trainings around child welfare. I would say look for them, go to them. The Court Improvement Program puts on trainings of these type in different areas, and you can go to them, not just the ones that are in your district. Your district liaison is Sue Schaefer. She can hook you up with if there's other trainings around child welfare around the state. But make yourself available to do those, to stay ahead of the information, the best practices, so that you can use them.
Christine just put in a quick plug. So we're doing trauma-informed advocacy in Syracuse on Wednesday, September 25th. And then we're going to be doing a half-day presentation in Geneseo, which I know isn't super convenient for you guys, with Margaret Burt for 2 different sessions. But the good news is both of those will be taped and on the website probably by mid-November at the latest.
That's a great plug. Thank you very much. All right, I think I have time for one more, and I'm trying to pick the juiciest. All right, how about this one? Attorneys should participate in all placement decisions. How's that strike you? She's giggling. There's someone over there giggling.
Anyone else gotten a letter in the mail? Your client was moved 2 weeks ago or at some point in time, and oh yeah, didn't we tell you about it?
Yep, that resonated.
And I've got to add to that one where I called the facility in Rochester to advise them that I was coming to visit little Susie, and they wouldn't tell me whether or not she was still there.
Mm-hmm.
And I went all the way to Fort Knox and broke in, and it didn't do any good. I finally called one of my colleagues in our local department who said, I'll get you the information. Little Susie is now here, and I'll tell you where she is.
Mm-hmm.
We can't do it without an authorization. I said, look, I'm her lawyer. I'm the authorization.
Didn't care.
Didn't care.
Yeah. So this one's hard for us here in New York because we don't have a statute, at least yet, that requires that the AFC be advised before any changes of placement for the child. I will tell you that is on the agenda of the Family Court Advisories and Rules Committee in your state, in our state, and it has been for years. It's been on there for years. When I was a member of that committee, it was on there. It consistently gets opposed by the Office of Children and Family Services. It's an extra layer, right? It's an extra layer. Yeah. So placement decisions are generally, that's something that's sacrosanct to them, sacrosanct, that, the judges aren't supposed to make specific placement determinations, specific. They control a lot of that, and then they value that. And so they oppose that.
As far as placement decisions, I have a hearing tomorrow that I've been fighting with to move a child back to her old foster home. And DSS has opposed it, so now we have a hearing on that. She's 17, wants to go back to the home she was in for 5.5 years. And the judge can order it if they find it's in her best interest, so that's why we're having the hearing under the Family Court Act and the case law. But in this particular case, DSS didn't know they could, and it just became just a lot more fight than it needed to be.
Yeah.
Or is being, I think.
And with former foster parents, there's legislative intent why they put former foster parents who had the child in their care for a period of 1 year on notice for permanency hearings, right? It's not just for, we want to generate more paper. It's because they could be resources for that child. So, you have a lot of stuff on your side there. But there are placement decisions that you have a very big stake in, right? And you can be influential around removal right? What's the standard at removal? Imminent risk. Right. Right. So you have to know your client's position and advocate that based on your position, based upon that client's position. Don't assume imminent risk because it's alleged in the petition. Just don't. And again, like we talked about before, what were the reasonable efforts to prevent removal? Are there efforts to be made that weren't made? Again, the judge's article. If you haven't met with your client, ask for a brief adjournment to do so with those removal hearings. I know, they're going to be cranky. Sorry. I have to represent my client. I have ethical obligations here. Sorry. They can say no, and you can ask. And don't rely on either DSS or the respondent's attorney to make the case that you're advocating for that's worth repeating again. Let's see. Pre-fact finding. What's the standard at that point? Same, right? Imminent risk, 1027, 1028, the standard's still imminent risk. Post-fact finding or at the time of return, what's the standard? What is it? I'm hearing sort of weak best interest. Do people think it's best interest? It's best interest, plus the permanency hearing statute has this crazy provision in it that I used to call, when I was a referee, the crystal ball provision. I would say, well, now I'm pulling out my crystal ball to determine whether or not there will ever be risks to the child of future abuse or neglect, and I have to find that there's not. So my crystal ball says that there's not, and the child can go home. It can't be a pure best interest standard, though. Right? I mean, it's not a best interest custody standard. We don't have foster parents and bio parents on the same plane. We've got legislative history all over the place and case law that says it's in the child's best interest to be with their family of origin. So is it really best interest? That's really kind of crazy. But is it? I've heard people argue that there's no longer imminent risk. It really can't be that either, because really, once the child's removed, there's no imminent risk, right? So you take the child out, whatever, the child can pretty much go back quickly because there's no imminent risk, but child could go back and there'd be imminent risk again. So there's got to be something in between. And I will say to you that the judges have been trained to start asking questions, and you might have heard them, maybe, hopefully, say, can the child be returned safely home today? Or why can't the child be returned safely home today? And we talk to them about asking that at every appearance. And the key word there is safely, right? And so what does safely mean, right? It means that there's safety factors that are removed, that there's not imminent risk if the child goes home, and that the highest risk factor's behavior has changed, that the child can go home. What it doesn't mean is completion of services. And that's what it means, right? That's what we see all the time. Child can't go home because services are not complete, or they're incomplete, or they haven't been referred. Child can't go home. Same thing with unsupervised versus supervised visitation. Is the child safe? Does just because a child was removed, they have to be supervised? Think about it. I think that's our knee-jerk reaction all the time, right? Child's removed, must be unsafe in mom's care. No, maybe unsafe to live with mom right now, but mom could probably be fine in a public place.
Christine, if I can interrupt, I apologize because we only have a couple minutes. But on that particular issue, DSS has given that authority over to their vendor. So when there's a removal, House of Good Shepherd requires every parent and even non-parents who have a visitation order have visits on campus before they'll authorize anything else. And I'm just saying that's the practicality. So at least until the next court appearance, that is the standard, that it's supervised. Even if there's a pre-existing visitation order for somebody else. I've had House of Good Shepherd require a non-respondent parent to come to the House of Good Shepherd and have supervised or at least on-campus visits. So that's the practicality that we're dealing with in this county. And you can fight with DSS all you want, but they'll say, oh, it's not our policy. And House of Good Shepherd says, that's our policy. And so that's what we're stuck with.
Bring orders to show cause. Start challenging the system.
And you can. And like I said, you specifically have a judge order. And I'm telling you is, I have not had much success in getting, occasionally, if I have a if I have a teenager who's able to voice it directly, I've had a judge direct non-supervised visitation initially. But absent that extreme factor, it's supervised. Even if I raise an issue, even whether I'm the respondent's attorney or the attorney for the child. The bottom line is until they get to campus, and you can bring orders and you can do whatever, but time passes. So I'm just saying it's easy for us to say that that's the standard. Safety, as a practical matter, it's being decided for us.
So I'm going to say this to wrap up and just say that none of this work is easy. And a lot of what we talked about here today is definitely against the norm. It's against the policies. It's against the way things are done. But just because it's the way things are done doesn't have to be the way things are going to be done in the future. And it's tough and it's hard to fight City Hall. And I would say just, keep the faith. And if you really have that case that lends itself well to following up on it, bring the order to show cause, get the denial, and file it up. Just keep working at it. You guys are all doing a great job. Please share some of this information with some of your colleagues who you may think are not doing as great a job. And I look forward to working with you. Thanks.
Thank you, Christine. Appreciate that very much.